Today, we're going to be reacting to the Young Thug trial going on in Atlanta. My name is Alicia. I'm a criminal defense attorney, former prosecutor. What I'm going to do is play the trial, the opening statements, all the way until we get to the end of day one. I'm going to stop intermittently, talk about things from a legal perspective, analyze things, talk about my thoughts and opinions. So if you wanted to just watch the trial straight through without any commentary, legal commentary, this is not the page for you. But for everybody else, I'm excited. As you know, I used to work in the Fulton County District Attorney's Office. This is the same office that is prosecuting Young Thug. I've worked with many of the prosecutors who are there now, who are on the prosecution, and now I'm a defense attorney. And so I've worked with a lot of defense attorneys in this trial as well. So without further ado, let's get into these opening statements. Judge Glanville is the presiding judge in this particular case, and opening statements for the prosecution is Prosecutor Adriane Love. Okay, let's get into it seriously this time.
All right, if you wish to make an opening statement at this point in time, please go ahead. All right.
I'm going to now share my screen with for permission.
Yes, ma'am. Go right ahead.
Now, this is the law of the jungle, as old and as true as the sky. And the wolf that shall keep it may prosper, but the wolf that shall break it must die. As the creeper that girdles the tree trunk, the law runneth forward and back. For the strength of the pack is the wolf, and the strength of the wolf is the pack.
Okay, let's go ahead and stop right there already. So when you give an opening statement, there are a lot of different ways and styles that you can do it. It's really going to be up to you. Some people like to start, as Miss Love started, with a quote from a book or something of that nature. I like to start my opening statements with some sort of hook, the same way that you might start a YouTube video or a TikTok video or an Instagram video or reel, something like that, right? Something that's going to draw the audience in and have them curious about what you're talking about. In this particular case, Miss Love started with the quote, I didn't love it. I didn't hate it. I'm sure as a great prosecutor, an experienced prosecutor would do, she's going to wrap that back into her opening statement or weave it throughout the entire prosecution as the really talented prosecutors do. I'm not sure. But as far as the opening, the quote from the book, I thought it was just okay. But again, it's easy to armchair quarterback, which means that it's easy for me to sit here and judge when I'm not up there on trial. So remember that, take this with a grain of salt, and let's do this all in good fun.
Thank you so much, ladies and gentlemen, for being patient. Thank you so much for being honest during this very lengthy process that preceded this point here today during the voir dire process. I appreciate you all being here, exercising your civic duty, and honoring your obligation to pay close attention to what's going on in this courtroom for the next however many weeks. Some people like to say that opening statements are a roadmap to what the trial will show. Instead, I'm going to give you an overview, a bird's eye view, because you're going to be sitting here with evidence for the next several weeks at least. And you will be able to see what that evidence is.
Right. I think that's really good. So if you didn't catch what she said that a lot of people like to refer to opening statements as a roadmap to the trial, right? And I generally tend to agree with that. Opening statements, not opening arguments, as some people might say, and sometimes I might say as well, but essentially this is a statement. This is what you expect the evidence to show. You got to remember, this is after months and months of litigation as to what can come in, what can be kept out, what's going to be said, what's not going to be said, right? So during the opening statement, you're giving the jury an idea of what they can expect to see in terms of evidence, video, witnesses, testimony, so they have a bird's eye view of the case, as Ms. Love said, so that they're not kind of confused as the case is going on, especially when you have a kind of complex trial such as this one. You need to be able to have an idea of what's going to happen through and through.
Nothing that I say to you during this part of the trial, and nothing any other attorney says to you during this part of the trial is evidence.
Okay, so she said nothing an attorney or anybody says to you during opening statements is evidence, and she's absolutely correct. But as a practical matter, I don't know if that's exactly how juries take opening statements, right? From my perspective, what I think is that when juries get in the room and they sit down, everything they're looking at hearing is they take that as evidence, but legally you're not supposed to take that as evidence. This is just an overview of the case. The evidence comes in after opening statements, when the witnesses are produced and when the lawyers are going back, cross-examining, direct examination, that's evidence. So again, opening statements are not to be taken as evidence.
But I can tell you what I expect the evidence to show. And what I expect the evidence to show in this case is that YSL, the group made up of the defendants sitting before you today, along with other both indicted and unindicted co-conspirators, YSL operated as a pack. The quote that I read to you earlier is from one of my favorite books as a kid, The Jungle Book. In case anybody recognizes it, those were
Okay, I was wondering where that quote was from. Okay, The Jungle Book. Let's get into it.
Kipling's words and not mine. But they are appropriate for where we are today. For 10 years and counting, the group calling itself Young Slimelife dominated the Cleveland Avenue community of Fulton County. They created a crater in the middle of Fulton County's Cleveland Avenue community that sucked in the youth, the innocence, and even the lives of some of its youngest members. Now, the evidence is going to show that this group started out as a group called Rock Crew. And Rock Crew stands for Raised on Cleveland. The evidence is going to show you that Rock Crew, in fact, is a criminal street gang. It's not the kind y'all are used to. If you're more familiar with the national gangs, such as the Bloods and the Crips, that operate in LA or in Chicago. But make no mistake about it, Rock Crew is and was a gang. It consisted of 3 or more members with common identifiers, signs, colors, linguistic choices that committed crimes on behalf of and in furtherance of Rock Crew itself.
Right. Okay. So now you hear Attorney Love getting into some of the requirements of being considered a gang or participating in street gang activity. Did you hear what she said? 3 or more members, they have identifying markers or words that they use to identify each other, and they committed crimes in furtherance of whatever the gang's purpose was. So here she's talking about how YSL started out as something else, and then she's going to go through, I'm assuming, how that Rock Crew became YSL, but that's extremely important. What she just went through there are the elements of a gang charge. So we're going to have to, as we watch the trial, we're going to have to make sure that the prosecution is meeting that burden and showing that each of those elements exist in this case. Now, of course, it's extremely easy and simple to label somebody as a gang. 3 or more members with identifying symbols and markers. Okay, 1 and 2 are very easy. Number 3, it gets a little harder. Committing crimes to further the gang, right? What the prosecution is going to show essentially is that any crime, and I'm a little biased against the prosecution in these particular cases, is that any crime that's committed by any gang member is in furtherance of the gang. And I always argue, and defense attorneys always argue, that's not true. We don't know what, person number 1 was over there doing. That has nothing to do with person number 2 or number 3. Even if they are in a gang, what does that matter? Also, it's not illegal to be in a gang. We'll get in. Let's continue on.
That particular organization aligned itself under an umbrella of a larger, more traditional street gang called Sex, Money, Murder, Bloods. They adopted the nomenclature. They would do things like replace C's in words with the letter B, because traditionally Crips and Bloods were not aligned with one another. So Cleveland Avenue became Cleveland. Some of you may have indicated during voir dire you've heard or are familiar with the Cleveland Avenue area. Maybe you've even heard of Cleveland Avenue Day. The evidence will show that this is where that comes from. The evidence will also show that sometime in 2012 or thereabouts, an internal rift or divide occurred among the members of Rock Crew. Now, the defendant, Jeffrey Williams, seated back there yawning right now, he was an original member of Rock Crew.
Wait a minute.
And the kind of crimes that—
Did she say the defendant Jeffrey Williams sitting back there yawning right now? Okay, that was a little bit out of pocket because it seems like she's trying to show that he was bored during the proceedings. He's not taking the proceedings seriously. I don't know what time it is. I don't know if they're getting much sleep. I doubt he's getting much sleep in the county jail. I don't think it's particularly comfortable there. So we don't know why he's yawning. But for her to point that out, that was a little bit of shade, Attorney Love? I don't know.
that Rock Crew did consisted of smash and grab burglaries, stealing ATM machines, things of that nature. When Rock Crew split up, YSL, or Young Slime Life, was formed. And the defendant, Jeffrey Williams, was its proclaimed leader. Young Slime Life came about and consisted of 3 or more people when it began. 3 or more people who were willing to and who did commit criminal street gang activity, that is crimes, that were intended to further the purposes and advance the directives of YSL itself. Now, there will be no evidence of a written contract or anything like that. You won't see bylaws of YSL, because this was a group of people associated in fact, who used common identifiers, common names, common colors, common symbols to communicate with one another.
Okay, so that makes sense, right? What the district attorney is saying is that when they're proving that YSL is a street gang, they're not going to have any written contracts or anything like that. They're going to be using the gang symbols. They're going to be using photos. They're going to be using the rap lyrics. They're going to be using things like that to try to prove their case. But we're not going to see any of this really concrete smoking gun evidence. And I guess the prosecutor is trying to really set our expectations as to what they are and what they are not going to show.
To express themselves to the rest of the world. So YSL, as the evidence will show, they didn't move individually. The members and associates of YSL, they moved like a pack, with the defendant Jeffrey Williams as its head.
Okay, so there's a PowerPoint somewhere. We can't see it, but it's okay. We can get the
You'll
truth.
hear from witnesses, both law enforcement and lay witnesses, who personally experienced and who personally witnessed the activities, the crimes that were committed. You will hear from law enforcement officers like Kimberly Underwood and Tyrone Dennis, whose main goal wasn't to go out in the streets and lock up people who look like them. It was actually to touch souls in the streets, to touch young people, and to alert them of the dangers and the drawbacks of becoming a part of and becoming involved in gangs like YSL and Rock Crew. You'll hear about conversations with educators. You'll hear from members.
Here we go. So remember when I was telling you about an opening statement is a roadmap? Right now we're getting to the portion of the roadmap where the prosecutor is going to tell us about the witnesses who are going to come and testify on behalf of the state. They might even get into some of the witnesses that are going to testify on the other side and start poking holes in the defense witnesses right now. But that would not be wise because the prosecution doesn't know what defense witnesses are going to be called and what defense witnesses are not going to be called at this stage. So really the prosecutor, as experienced as she is probably only going to focus on the prosecution's witness and what they're going to attempt to prove in the case in chief.
And associates of the gang itself. Now, as to how those members and associates will respond or act once they're actually in court and on the stand, that's something that I am truthfully not able to predict to you fully.
So what she's saying is that she doesn't know if her witnesses are going to be hostile or not, meaning that the prosecutor doesn't know if the witnesses are going to be on the stand like, I don't want to be here. You forced me to be here because you sent a subpoena and an officer to my house and told me if I didn't come here, you're going to put me in jail. So ask me your questions and keep it pushing, right? She doesn't know, or she doesn't know if they're going to want to work with her and tell about YSL. A lot of the witnesses probably don't want to talk about YSL because if YSL is a street gang, as the prosecution is alleging, of course, these people don't want to sit up there and talk about the crimes because they're going to be afraid, probably that their lives are in danger. But also, right, on the flip side, they might not want to talk about anything because nothing happened and YSL is not a street gang. So those are some of the things we can anticipate. Remember this as we're watching the trial later. Remember, Alicia said some of these witnesses are going to be hostile and fighting back against the prosecution. The prosecution's own witnesses are going to be doing that. It's going to be an interesting trial. But also that's something that happens in every trial. Don't get it twisted.
It's giving you instructions on determining and judging the credibility of the witnesses. And I trust that all of you will in fact follow those instructions. The evidence will show that YSL checked all of the boxes for being a criminal street gang. As I stated earlier, they are 3 or more people associated in fact. Their members commit crimes on behalf of the gang. They commit crimes such as armed robbery, hijacking, motor vehicle theft, theft by receiving, stolen firearms, so many stolen firearms, possession of a machine gun, and narcotic sales. And last but certainly not least, murder. What you will not hear any evidence of is that the defendants were not involved in a criminal street gang. You will not hear any evidence that they did not commit crimes on behalf of YSL. And as I stated to you earlier, what I'm saying to you now, this is
let me object.
Okay, I don't know if you saw my face. I knew it was coming. So there's going to be an objection here because you as a prosecutor can't talk about what you will not hear evidence of. It sounds like burden shifting to me, which means that you're shifting the burden from the prosecution to the defense. The defense doesn't have to prove anything. The defense really doesn't have to say a word. They could just sit there and let you present your case and let you flop and then come up at the end and say that the prosecutor didn't show this, the prosecutor didn't show that, the prosecutor didn't show this, that, and that. That's how you destroy a prosecutor's case. That's not how you destroy a defense attorney's case because the defense attorney doesn't have to show anything. You can't put the burden on them. So I'm sure this objection here is about to be, excuse me, you can't talk about what the evidence will not show. That's burden shifting. Let's listen in here and see what the objection is going to be.
To that statement, please, is burden shifting.
Basis?
Burden shifting. And under Parker versus the state at 277.
Why don't we take that up and I'll note your objection. I'm sustaining the objection. Why don't you rephrase, madam?
So the judge abstained. The judge sustained the objection of burden shifting. That's exactly that was the right objection to make. That's an extremely experienced defense attorney back there making that objection. So yeah, you can't shift the burden onto the defense and talk about what you will not see. So that's why that objection was sustained. And, Attorney Love, the prosecutor in the white jacket, is extremely experienced. So when you see these things happening, I don't want you to think, oh, this is because the attorney is not experienced. That's absolutely not true. The prosecutor here has tried several cases, has been working at the district attorney's office for many, many years. And so these, what people might say, mistakes, are not because a rookie prosecutor is trying this case. Far from it.
Yes, Your Honor.
Mr. President. Ladies and gentlemen, I'm going to explain to you at the appropriate time, ladies and gentlemen, what the burden is in this case. Remember what I told you earlier, that the burden never shifts to the defendants to prove or certain innocence, they're presumed innocent. And it's only until you hear evidence that you decide is sufficient, and I'll instruct you on how you're supposed to do that at a later point in time, okay?
Right.
All right.
The evidence will show that YSL did not adhere and does not adhere to all of the customs of a traditional street gang. And the fact that YSL does not mirror all the customs of a criminal street gang, the evidence will show makes it no less a criminal street gang. The defendants on trial here today have, through their actions, displayed not only their allegiance, their alliance with one another and with the gang itself. Through their actions, they have displayed an unspoken agreement to participate in that gang through a pattern of illegal activities. And again, the head of this gang is seated in this courtroom too. The last paragraph of that poem that I read spoke to you earlier.
Okay. So remember what I was saying, when you open with a quote or some sort of theme, a lot of times you wrap it back into the trial later. So now Attorney Love is wrapping that quote back into the remainder of her opening statement, which I appreciate that. I think it shows that you took some time and you thought about it. Themes are not going to be for everybody. Quotes are not going to be for everybody. Some people are going to find it corny. Some people are going to like it. I tend to think that once you get out into the real world, out of law school, mock trial, moot court, you're going to be doing a lot of themes and, this truck hit that truck, bad truck, whatever, rhyming, whatever. But I do tend to think that once you get out of law school and you get in the real world, you got to be more careful because it comes across as just a little corny, a little gimmicky. There's some showmanship. There's a lot of showmanship in trial, but you just got to be careful not to come off as off-putting, something that the jury might not like or might not even resonate with. So let's hear how that quote from the beginning is wrapping back in right now.
As follows. Because of his age and his cunning, because of his gripe.
This is argument. This is not
What's your objection, Mr. Harvey?
that it's argument.
Okay, Mr. Harvey, hold on. Madam, it is argument at this point in time, so I'll sustain the objection, okay?
Yes, sure.
All right.
All right, so 2 objections sustained by the defense attorneys right now. The first one, burden shifting. The second one, that this is argument. So what he's saying is that an opening statement, they're statements. You're supposed to just give an overview of the trial, not get into argument, not get into trying to persuade the jury to your point, even though an opening statement is persuasive, but you're not supposed to be arguing. So what it sounded like the defense attorney was saying was that when Ms. Love was trying to get back into the second portion of the poem that she wanted to wrap in, or the book, whatever that she wanted to wrap in, she was about to start making an argument comparing Jeffrey Williams or whatever member of Young Thug she's talking about, or of YSL that she's talking about in the trial, to whoever these characters, Wolf, whatever she was about to do, but we'll never know because the objection was sustained, and so she's gonna have to move on to the next point.
The evidence will show that these defendants, that the members and associates of YSL, they knew who their leader was, and they knew the repercussions of not obeying their leader. You will hear evidence that when members and associates of YSL got in trouble, got locked up, the first person they called was either this defendant or one of his family members. Now, they didn't call him directly because he knew and they knew that he needed to have distance between himself and the crimes members and associates of YSL were committing on behalf of the gang. So they would reach out to his sister and have his sister reach out to somebody else and eventually get back to King Slime, as they call him.
That's wild. So what she's saying is that Young Thug was a sophisticated gang leader, and he knew that he couldn't have the person who committed the crime call him directly because that's, trackable, easily traceable, easy evidence for the state. Boom, boom, boom. You go into prison for the rest of your life. What the state is alleging and what they're going to try to prove is that whoever committed the crime would call Young Thug's sister. The sister would call somebody else, and then would telephone and would get back to Young Thug. That's crazy, to have the sister involved in something like this as a messenger. Not crazy, but that's something that I didn't know before, but I guess it happens all the time in organizations, as the district attorney is saying, that are gang organizations. So we'll see if they can actually prove that. I wonder if the sister is going to come in and testify. We'll see.
You will hear evidence that members of YSL committed armed robberies. You'll hear evidence that to slime someone is to do them dirty, and that sometimes members of YSL committed crimes against other family members of their fellow gang members. You'll hear evidence that when one of the associates or members of YSL did something to what Jeffrey Williams had perhaps considered a friend, they were threatened with their very life. Tell them to get that stuff back or they will be killed. You'll hear evidence that YSL, they had opposition within the city of Atlanta and Fulton County. That there were other gangs that were at various points in time at odds and even at war with YSL. One of those gangs was known as the IF gang, IF, Inglewood Family. You will hear experts come in here and tell you more about.
Okay, this is interesting. So there's another gang called Inglewood Family in Atlanta beefing with YSL. I didn't know we had an Inglewood family gang in Atlanta, but what you'll learn throughout this prosecution is that gangs currently aren't the way that they used to be. And I don't know if the state is going to get into this, but what you'll see these days are a lot of hybrid gangs, a lot of shoot-offs of gangs. So, sometimes Bloods might work with Crips, quote unquote. Those are the two big popular main ones that everybody knows. But now, there's all sorts of gangs, different gang names, different stuff like that. And they'll work with each other sometimes for a common goal. So, it's not how it used to be where it's like, oh, I'm a Blood, you're a Crip, we don't talk. In Georgia, at least, you'll see a lot of switch up from that. And we'll see if the prosecution is going to get into that.
How the Inglewood family Bloods in any way made its way down to Fulton County. You will also hear evidence about how one of the members, one of the beloved, of whom YSL considered an opposition group, was gunned down. Donovan Thomas on January the 1st, 2015. January the 10th, my apologies, 2015. Gunned down, openly and notoriously. Because the evidence will show that part of the reasons that criminal street gangs operate the way that they do is to establish dominance and to establish control and to establish fear. You're going to hear that this gang stole at least 3 lives from this community over the last 10 years. At least 3 that are referenced in this indictment.
Okay, so that's definitely relevant, right? Any life loss in a particular prosecution like this is going to be relevant, going to be important. But it's interesting because when I was looking at the media for this trial, and when everybody was talking about it in the news, they made it seem like, you know what I'm saying, YSL was out there, like 20, 30, 50 people. Like I was expecting the body count of people who were murdered to be much larger in this particular case, but it sounds like the state has only charged 3. And what that further means is that they feel like they can only prove 3. And that's not to say that the state doesn't believe that more happened, and they probably do believe that more happened and occurred. That's why she said only 3 that are charged in this indictment. If you read between the lines, I think what she's trying to say is, you know what I'm saying, we really think there's some more bodies out there, but we can't prove it, so we're going to go with these 3. And that was interesting because, again, I just thought there were more than that. So, yeah. Okay, back to it.
You'll find that as a result of this gang's activities, a young woman who had nothing to do with either YSL or any of their opposition was gunned down by people trying to get back at YSL for what they did. You'll hear evidence that after the murder of Donovan Thomas, no less than 50 shootings occurred over the course of the next several months. You'll hear evidence that hundreds of bullets were fired into cars, into homes, and into people as a result of the rift young Limelight had with other people in the community.
Wow. Hundreds of bullets. Crazy.
So what are they accused of, and what are you here for today?
Get into it.
The judge read the 4-hour-long indictment to you 12 months ago.
Hold on. Did she say 4-hour-long indictment? The judge read the 4-hour-long indictment. This indictment and this trial is crazy. This, I don't know if Georgia has ever seen anything like this. Certainly, I know that we have never taken this long to pick a jury. It's been 10, 11 months to pick a jury. I'm surprised the trial is even taking place before 2024. But a 4-hour-long indictment is crazy. The state really took on a big kahuna with this one, a big boy with this one.
He didn't read it to you again today, but he generally gave you what each defendant is being charged with and what the state has the burden of proving beyond a reasonable doubt as it relates to each defendant. But just to broadly touch on those, the crimes that the state is proving to you over the next several weeks include conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act. That is an absolute mouthful. So we'll just say RICO. There's no substantive allegation of RICO violations here. And by that I mean there's a difference. Here the state is alleging that these defendants, they had an agreement, unspoken, but no less an agreement to obtain property, things of value, cell phones, cars, stolen guns, through a pattern of illegal activity. The evidence will show that it's sort of like if two people said, okay, you know what, we're gonna go toilet paper our dean of admissions house.
I've done that. No, not the dean of admissions.
And they sat there thinking and talking about it, and someone overheard them and reported them to the police. And the police came and said, okay, I'm gonna arrest you all for conspiracy, for planning to go and do this. The evidence will show that it's not enough that they were planning to do it. Somebody has to do at least one thing in order for those two people to be found guilty of conspiracy.
Okay, so she's saying it's not enough for you to talk about or plan on committing a crime for this particular offense. It's not enough for you to talk about, we're going to go steal a banana from Kroger, and then nobody does it. Nobody does any moves towards stealing the banana, right? She's saying that there's some act, right? There's something that happened. There was something that's a step forward in committing the conspiracy.
So say one of you goes and says, let me go get the toilet paper now. Then y'all are in trouble.
Right. So if you're talking about stealing a banana from Kroger, and then y'all say, okay, well, first we need to buy, a mask to cover our faces, and you go buy those masks, you in trouble. That's what they're saying. That's what the state has to prove and act, a step forward towards the conspiracy, not that you actually committed the actual crime. You follow me?
That's what we have here, and that's what the evidence is going to show. There was an agreement among the members of YSL to obtain property and things of value through a pattern of illegal activity. And it is their actions over the course of the last 10 years. It did not stop, by the way, in 2015. It didn't stop at all.
Yeah.
I think I found the solution to
this is wild because not a commercial. This is wild because they're saying this happened over the course of 10 years, which is wild, which means the state has been investigating this for 10 years, deep into this before they decided to bring an indictment. I don't know why this particular administration decided to bring this indictment, because there was a prior elected district attorney before Attorney Fani Willis got on board, and the prior DA didn't bring these particular trials and crimes to court. And so I'm not sure why they decided to do it now. I'm not sure if the investigation concluded now, or if the current district attorney felt like the evidence was there and she had seen enough. At any rate, it's wild that this has been investigated for 10 years.
To go into this, the evidence will show that it's not enough that they were planning to do it. Somebody has to do at least one thing in order for those two people to be found guilty of conspiracy.
Mm-hmm.
So say one of you goes and says, let me go get the toilet paper now.
You're in trouble.
Then y'all are in trouble. That's what we have here, and that's what the evidence is going to show. There was an agreement among the members of YSL to obtain property and things of value through a pattern of illegal activity. And it is their actions over the course of the last 10 years. It did not stop, by the way, in 2015. It didn't stop at all. It continued up through and even into 2023. After this case was indicted, as the evidence will show. But their actions are what the state will be looking to you to evaluate and determine, does this action show that they are agreeing to participate in this organization, this enterprise, through racketeering activity? You'll see evidence, as I stated, of not just drug sales, trap houses, drug houses, whole houses out of which drug sales were conducted.
Not the trap house.
Where they held longhorn guns by the door. Where they stood ready to act on command if either one of their number called. Who's on trial before you today is Rodelius Ryan, Pomarius Nichols, Marquavius Huey, Jeffrey Williams, Shannon Stillwell, Diamante Kendrick, and their actions during the dates that are listed in the—
Okay, so a lot of people took pleas in this case. A lot of people were indicted to begin with, and now we're down to 6 people who are left. That means everybody else took a plea, their cases were dismissed. 6 people are left on trial. Interesting. I wonder if any of those 6, any of the people who took pleas already are going to come back and testify on behalf of the state. Let's see.
This indictment are what we are asking that you pay close attention to and you evaluate.
Your Honor.
It-
You have an objection?
Yes, sir.
Basis.
Motion.
Oh, okay. I want everyone to know that it's not normal to have objections during opening statements. Typically, opening statements, you talk and you don't get objected to as a matter of style and also as a matter of preference. But if the prosecutor is saying something that is inappropriate, shouldn't be in the case, then yeah, you have to object. I mean, it's up to the attorney to not have an opening statement that's going to go against the rules. And you don't have to just sit there and take that. But that also doesn't mean that you sit there and you object just to be rude or to be kind of annoying or to throw the attorney off their game. That's going to be really irritating, not just to the judge, but also to the jury because, oh my God, sit down, be quiet. But in this case, there's probably a really good objection coming up and the jury is going to have to be excused, meaning the jury is going to have to leave the room because if you heard the attorney, Mr. Steele said a motion, which means something that needs to be heard outside of the presence of the jury. So they're going to have to leave, hear that motion, and then the jury will come back in when they've concluded that argument and when the judge has decided how he wants to rule on that argument. So let's listen in and see what's next.
Um,
Come on, close up.
All right. Ladies and gentlemen, this is one of our breaks. I'm going to need to probably ask you to retire to your headquarters jury deliberation room, and we'll call you back in just a minute, okay, when we finish up our business, all right?
That's what I was saying. The jury is going to have to go
Remember the court's admonitions, ladies and gentlemen.
leave. And we're going to have to hear this motion. The jury can't hear it. There are a lot of things that the jury can't hear that has to be heard outside the presence of the jury. Of them, and I wonder what the objection is going to be. It came at a point where the prosecutor was naming the defendants in the case. And so I wonder if it's because she didn't name everybody, she left the other people who were indicted out. Let's see. Let's also see how much longer we have. Ooh, child.
All right, please be seated. Our jury has left us. All right, Mr. Steele, what's your motion, sir?
Good morning again, Your Honor. Your Honor, last week, 2 weeks, 3 weeks ago, you ordered the parties to share all of their displays in opening statement to the others so we don't have to have these interruptions. I did that. The state shared with me 4 attachments. That's all they had. That's what I got. What you just saw on your screen, if you don't remember, I'll ask the state to put it up and I asked for it to be marked as exhibit, is what you already excluded. It states that Mr. Ryan was convicted of murder and I represent the co-defendant who's not on trial on the appeal. How did that not get sent to me so I could bring it to the Honorable Court's attention? 1. And 2, how do we just violate court orders? So yes, I have a serious motion for a mistrial because it's intentional misconduct. That's my motion.
All right.
And I'd like the screenshot to be captured from Mr. Weaver to put in the record.
I'll admit it is next.
A motion for a mistrial already? We're in opening statements. The trial ain't even really got started good yet. Okay, so what Mr. Steele was saying was there was an exhibit that the judge had already excluded, talking about someone who was convicted of murder, that they already talked about, already was supposed to be excluded, and somehow it made its way into the state's slides, the case in chief, not the case in chief, but into the opening statement slides, the PowerPoint presentation. What the defense attorney is saying is that the state is supposed to share all of that, the opening presentation with the defense so that they can look through it and tell the state, no, you can't put this in here. You can't say that. You need to take this out. And so that everybody is on one accord so they don't have to have these interruptions. But what Mr. Steele said is that the state either added in a slide or didn't show him a slide. And there's a slide in there that's not supposed to be there that is they've already discussed should be kept out of the trial. So he's asking for a mistrial. Let's see what the judge says. Probably not going to grant a mistrial. But if this is how we're starting a little rocky. Starting a little rocky for the prosecution. I don't know if I don't know, but you can't be making these types of mistakes in a trial where you're trying to put people in prison for the rest of their lives. You really need to be on your A game. You need to be on point.
It's court exhibit in order of the state's presentation anyway. So All right, so that'll be court one for purposes of the trial. So, Ms. Love, what's your response to Mr. Steele's assertion about Mr. Ryan?
As it relates to Mr. Ryan and the exhibits that the state intended to play and to display for the jury, I sent to Mr. Steele and everyone else the pictures and the photographs that I expected to use. As it relates to the slide to which Mr. Steele is now referring regarding his representation on appeal, I'm not certain if the objection goes to the fact that there was the conviction, because that's part of the indictment and that's part of the evidence that the state expects will show, or if it's as to his objection about the fact that he represents Mr. Ryan or Mr. Blaylock on appeal.
Don't represent Mr. Ryan.
Mr. Blaylock, then.
Excuse me. I would never said this ever. That's it.
Okay, what's your objection based upon, Mr. Steele?
Objection based upon, I argued this before this honorable court. You argued the prosecution that before they ever mentioned my name, you granted this motion.
That I did.
You brought him up to this honorable court, outside the presence of everybody. You heard an opening statement. I am lied to. I am saying that. I am lied to. Or if anyone else got that exhibit, I did not get that exhibit. And I see everyone says shaking no. And now, it goes against the court's order. We are bound, duty bound to follow some of the court's order.
I'm going to join in the objection on behalf of Mr. Steele.
Let me see the.
I can put it back up,
Yes,
Judge.
ma'am.
And Your Honor, while I am putting that back up, I will state in my place that initially when there was the objection from Mr. Steele, I didn't have a clue what it was about because I didn't mention his name and didn't intend to mention his name. As I looked at the screen, I saw that part of his name was on the screen for the most part.
But I mentioned that, I ruled upon that last week. I did. That we were not, I would take it as it came in this case. And if the evidence got to that point, then I would deal with it accordingly.
Yes, Your Honor.
So,
And Your Honor, as to Mr. Steele's motion, as I'm pulling this up, the state would vehemently object to a mistrial and ask
Of course.
for a curative instruction and a reminder to the court, to the jury, that nothing that the lawyers say is evidence in this case.
This is wild. I got to get into this. So the state made, I'm going to call it a mistake. I don't know how this document got into the opening presentation that's not supposed to be in there. I don't know if the state made a mistake. They haven't explained why it's in there. What they're asking now, though, is although there's this document that the judge has already said should be excluded, and I don't know if he said that because, it's prejudicial to the defense attorney and to the defendant, probably because it's prejudicial, probably because it's going to taint the jury away from believing Mr. Williams or away from believing the defense attorney, Brian Steele. I don't know. But the state is now saying, hey, we know we made this mistake. We know the judge said don't put this in here. But instead of doing a mistrial, just remind the jury that nothing we say is evidence in opening statements. I think that's the best argument to make if you are a prosecutor. But also it's like, it feels a little, it just feels like it's not right. Like you shouldn't be able to just have, make these large mistakes. And you are the prosecutor. You're trying to put people in prison and just say, well, it's fine because it's not evidence anyway. It feels a little... I don't like it.
Not at all the type of thing that rises to the level of mandating a mistrial. Certainly not. It just isn't. I have the...
all right. Court one for purposes of the motion for mistrial.
Good job. Not the camera quality being on my iPhone 1. Come on, 11 Live, get it together. Ooh, not they zoomed in on the slide. Okay, this is light is not supposed to be there, but we can't see. Okay. Oh, let's pause this. All right, so represented by Brian Steele. Oh, they're trying to say that. this slide is not supposed to be in there because it says that somebody else who was convicted, but I guess is on appeal of a crime, was represented by Brian Steele. You can imagine how that's not a good look to the jury, right? How that could persuade the jury against Brian Steele, make it look like, oh, all he does is represent, murderers and drug dealers, and this is his MO, and his clients, if he represent those clients, they definitely did it. You know what I'm saying? Like, you never know what the jury might think. And so to just ignore all that, get it out, you don't even need to have the slide in the trial. And the judge already said no, and here it is, live and living color. Thank you, 11 Alive, for zooming in. And then they didn't even put the man's whole name on there, Brian Stee, child.
All right. Yeah, on slide 11 of 65, that I see where you have that at the bottom, represented by Brian Steele. So
why they even put that in there?
we can leave that for the time being. Leave it for the time being because it is what it was up. I'm going to deny the motion for mistrial, Mr. Steele, but I will go ahead and give a curative instruction to our jurors at this point in time. So,
Your Honor, I'm supposed to ask for a reoccurrence report for my mistrial before the next process goes on. I'd like you to do me a courtesy, if you would, and allow me to do that now and preserve the motion for mistrial.
you've made your motion for mistrial, and the basis, and I'm going to mark the whole state's presentation as is as court one for the purpose of your motion, and it will go in as stated.
I have two other issues I'd like the court to just take up. One,
Come on.
just remember, I know you ruled on it, but the state said earlier today that Mr. Williams is contacted through parties that they don't know to pay for other people's lawyers. So I think that couples with that exhibit. And number two, I'd like the court to now order prosecution to give me and anyone else who wants to see it. I need to see respectfully what you ordered last week, all of the displays of the state of Georgia that they have not given to us.
What do you mean by what displays are you talking about, Mr. Steele?
I never saw that. I never saw the wolf. I never saw the indictment. You ordered I gave all my displays. I gave everything to the state. I got from the state.
Are you talking about using for opening statements, sir?
Of course.
Okay.
Should have been done.
All right.
He's not wrong.
All right, Ms. Love.
So what he's saying is that what Brian Steele is saying is that he provided all of his opening slides, whatever he's going to be using in opening statements, he provided that evidence to the state. And now the state is up here giving presentations and doing all this stuff, and they haven't provided it to the defense. And they provided, it sounds like, something to the defense, but whatever the finalized product has not been provided to the defense, and it's been altered in some way from what the defense has. And so, they don't know what's next. Are more things going to be included that were excluded? Are more things going to be in there that are not supposed to be in there? We don't know. So at this point, probably they're going to have to exchange that information before the jury comes back in. It's just going to delay opening statements even further. So now the prosecutor gets a chance to respond. They will always get a chance to respond. And let's see what they say.
Wait.
Thank you, Your Honor. Two matters, Your Honor. One, the first thing that Mr. Steele has requested of the court regarding the representation that the state made about other YSL members contacting Jeffrey Williams for representation is absolutely and has always been a part of what the state expects will show at trial.
I'm going to deny that portion. But to Mr. Steele's point, I'd already made that issue in terms of his particular involvement, and anything you need to let me know prior to that, and I need to rule upon it. And also subject to foundation, just like this. So I assume that what you told our jurors is what you expect the evidence to show. Yes?
Yes,
All right,
definitely.
so I'm gonna overrule that part of his objection. What about the last thing you mentioned?
And Your Honor, as to the court's directive that we turn over anything or any exhibits or photographs, that was my understanding of the court's directive, that we expect to show an opening statement. As a matter of course, I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele at least part of his name on
I
here.
got that, but he's talking about, is there anything else you're gonna use in open you haven't shown to the defense counsel?
I
He's
don't
telling
mind
us,
sharing.
well, I said that, I told you to do that a week ago.
Your Honor, thank
Because
you.
here's what I told you was gonna happen. I've got a jury that's out right now that's being interrupted. And Mr. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it. Not hijack me at the bench about that. You did what you had to do, but I'm not happy about that. I'm not happy about any of this. Because this is stuff we could take care of before our jury comes in. And that makes you all, lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen. So have you given them everything you're going to show them during opening statement?
Your Honor, I haven't given them all of the word slides. I did give to them what Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
can you do that over the next 5 minutes?
I sure can.
Deputy Ingram, can you find out if our jurors are ready? Are they ready? Are they still using the restroom?
I'll send that to them right now as we're waiting.
Okay, so what the judge is saying is that at the first point in time that one of the defense attorneys saw something that the state was presenting that they hadn't seen before, the judge is saying that they should have said something in advance or said something earlier, not all the way, after the state has done like 40 minutes of their opening statement. Okay, whatever. I mean, the defense attorney did what the defense attorney needed to do. They needed to object. I guess they didn't object when the judge would have liked them to object, but they were right to object. Maybe the defense attorneys didn't think that the state was going to continuously put more stuff up that wasn't in the initial slide. You know what I'm saying? Maybe the defense attorneys were trying to give the state some space. I'm not going to object right away to this first one. I'm going to let it slide because maybe it's not going to be too much. But when it keeps going, when something that is excluded is on the screen, you have to speak up. What the prosecutor is saying is that the slide that said Brian Steele was inadvertently added. Okay, cool. But they're also saying that there's other stuff that was added to the PowerPoint either last night when they were preparing, early this morning when they were preparing. I did hear her say last evening, but I'm sure they were preparing, up until right before they came into the courtroom. There's new stuff in there that they hadn't shared with the defense attorneys yet. And that's, saying, what is going on? Like, that's not how a smooth trial is supposed to be run. And that's why the judge is frustrated because you shouldn't be having this. Like when the trial starts, you want it to run smoothly. You want everybody to at least get through their opening statements smoothly and keep it pushing. But when you have interruptions like this, it interrupts the jury. They got to go back and they're kind of breaking their focus and of what's going on in the trial. Got to get them back in there. The defense attorneys and the prosecutors aren't advocating as strongly as they could because they have to keep getting interrupted. They can't really get into the motion and get on a roll of their arguments. So I understand what the judge is saying here. So now they're going to take a break and try to exchange all that stuff. This might be a good time as well for us to take a break from part one of the trial. I'm a criminal defense attorney in Atlanta. If you need representation, my firm represents criminal defendants. We also represent people who have been in car accidents, big wheelers, or, regular car accidents. Please contact us. You can find it at the link in the description. I also put my phone number below so you can call or text me, and I'll see y'all back for part two.